should and should not be in file retention agreement with the client. So that's pretty much all I have on the opinion. And I'm very interested in hearing everyone's thoughts on the issue of whether the opinion does enough to offer guidance on what should and should not be included in the file retention agreement.
I just want, I've been seeing some fee agreements lately that have, in my opinion, ridiculously short time limits. They say, they'll maintain the file for 30 days.
Really?
Yeah, I've seen a few of those, and and when you talk about the informed consent issue, the clients, often have signed the agreement.
Mm-hmm.
My guess is that probably, wasn't emphasized. Certainly the consequences weren't emphasized. It just says they'll retain it for 30 days and then destroy it or return it. I don't know how prevalent that is, but I've seen that in the fee agreements lately.
Out of curiosity, in the agreements that you've seen, do they disclose any additional facts or consequences, risks?
No, it just says, we'll maintain the file for 30 days and, either just, return it or destroy it, things to that effect. No at all about the consequences to the client if, their file's been destroyed after 30 days.
Well, Ken, that's kind of, in a way, a benefit to both the attorney and the client. Of course, the attorney gets the file out of his or her office. But second of all, the client has to pay attention to it while it's still fresh, rather than 6 years later when it might become relevant. But it would have to include all the disclosures, the risks, et cetera. And we won't destroy it until we've made every effort to return it to you, et cetera. So I'm not totally offended by it. I'm just saying it has to go along with a lot of the safeguards and disclosures.
Yeah, the ones I saw were missing that part.
So, Joel and Ken, does this opinion go far enough in instructing lawyers to make the kind of disclosures that we believe they should make in a file retention agreement, as well as consider the kind of considerations that they're supposed to think about in drafting the file retention agreement, I think would generally preclude the kind of, very short file retention agreement that, Ken, you're talking about.
It's pretty much is all covered in that footnote 4, right? Looks like it carries over onto the next page.
Yeah, in the 4, and I think it's addressed again later in like footnote 9.
At the bottom of the next page, is that a carryover from footnote 4?
Yeah.
Yeah.
Yeah. Well, there, I think that addresses the issue. Lawyers are advised to disclose the potential consequences and risks.
Does it go far enough in saying they're advised as opposed to they should or they must? Or
well, I mean, we use different. One of the things, Amber, is you use different language in the 3 different places where you talk about it. So someone in footnote 4, you say lawyers are advised to disclose, and in footnote 9, you said they should disclose, and then in footnote 13, you basically say that they can skip that notification of clients provided that they do disclose that. So that making it mandatory that they could skip that. So I think we need to determine the language, make sure that there's consistency in discussing that. Like what are we saying that they, is it advice, is it guidance, like they're advised to do it, it's a best practice, or are we saying that we think that it's required? So I think.
I mean, I don't,
Stated in those 3 places.
Dina, I'm saying, could you point out one more time which footnote you think suggests that it's mandatory, the disclosure?
Well, we say right here, we say advised to disclose, right? And then go to footnote 9.
I mean, I guess to me, advised and should sort of imply the same thing.
Okay, and then in footnote 13, we say that they basically, you're saying they can skip the step of, can you go to footnote 13, Mimi? You're saying they can skip the step of talking to the client, provided that they've disclosed the actual potential consequences as part of that process. So you're saying that, in other words, that's required. Like, they can't skip the step if they don't do that thing. And it seems to be that the implication is that that's required. Otherwise, they would have to go through this whole process again of contacting the clients. And I did have a question about that with footnote, because I do think that there's a lot of overlap, and particularly in footnote 4 and footnote 13. And if we could somehow condense that, or in footnote 13, refer to footnote 4 or something, because just so that there's not this risk of like using different language. Although I will say in footnote 4, you say only as to criminal matters at the end of that footnote. And I was wondering why we said that there.
I'm sorry, footnote, which one, 4?
Yeah. In criminal matters, like,
Well,
guys disclose the potential consequences associated in criminal matters. And this footnote is actually, like, even though it's on that page, it's in the general
right. And
background.
well, the reason why the reason for the specification for criminal matters is because at some point the committee thought that the opinion should give an example that was specific to criminal matters and explain why disclosure was particularly important in having the clients.
I agree that it potentially has more consequences in a criminal matter, but I don't think we should limit it to that, because we don't in footnote 9 and 13, we don't limit our discussion of it to criminal matters. And in fact, 13 talks about civil matters. And so I think we should probably take that reference out there.
Okay, yeah, that's fine. I mean, so delete just the last in criminal matters at the end of the footnote. Yeah. That's fine.
So I still do want to, I want to have comments or some feedback from others just about that issue about what we are saying. We're advising them. Is that a best practice? Are we saying they should? Is it required? Because I do think that footnote 13 suggests the requirement, because if you don't have, unless you've done this, you don't. So, but before that, I wanted to make another comment about something else so that I can, take my comments offline. And you've used the word unforeseeable in 2 different places that I think we should remove. One of them is in that footnote 4. Sorry, Mimi, because I know you just moved on. Where you say a client's need for the file may change due to the possibility of post-conviction review, unforeseeable change in the law. I don't see the need for the word unforeseeable. That's another place, because we're basically telling lawyers that they should, one of the reasons that they should do that is there's these anticipated things that might happen. And I don't think we should characterize them as unforeseeable. The law does change, that's foreseeable. What, to the extent it's going to change or how exactly it's going to change would be unforeseeable. But I think that we, the idea of changing and laws changing is something that I think we all know happens, right? Like that's not, so I don't want to suggest that we're going to be holding lawyers to a standard to advise clients about unforeseeable things, because by its very nature, it's something that you wouldn't be able to reasonably predict could happen, right? So I think we should take out that reference. There's also a reference to it in footnote 4.
That's fine. I think I may have gotten in one of the ethics opinions perhaps, but now I can't recall, but I'm fine with deleting that word.
It's in footnote 4 too, Mimi, if you could go to that. Yeah. Because, I mean, if we tell lawyers that they have to advise their clients or warn them about unforeseeable risks, they're they're not gonna like.
Understood.
Yeah. And then I thought there was one other comment that I had. I don't know. I thought on footnote 13, and this, if you could just go to that briefly, Mimi, this relates to our discussion on that other point that I raised, but I felt like that first sentence or so is kind of awkward. I was trying to figure out if we could say, you're saying they can skip the step where the file retention agreement, if there's a retention agreement where the client agreed to the destruction of the file as specified in the agreement. I was wondering if we could say something under specific circumstances in compliance with the lawyer's ethical duties or something like that to maybe avoid this other part about disclosing actual potential consequences if that's part of it, because I don't think people routinely have in their file retention agreements like disclosures about actual potential consequences of file retention. And so I don't, yeah, I feel like if we were more vague about if they basically agreed to certain terms that were in compliance with their ethical duties, which what I would think would imply, meaning it didn't violate duties of competence and other things that you've identified because it's 30 days and they're, you know, and they're prejudice and things like that. I know it's, and the other complicating factor that we talked about with this is the fact that most file retention agreements are in engagement letters, and that's sort of the arm's length transaction. And so we've talked about that. Now, whether there's a duty of other duties lawyers have related to confidence and duty of loyalty, you can make arguments to not, you know, once they've had that agreement to protect the client's interests. And these are, you know, having a longer file retention agreement can potentially protect client's interests. That's important that we've highlighted, but I'm a little uncomfortable suggesting that the file retention agreement has to say, it has to disclose actual and potential consequences in the way it's stated here.
Right, and that was not what I had intended to convey in that footnote. I think what I was trying to address was that all the steps that we recommend that the lawyers take before destroying the files, unless there is some kind of file retention agreement in place. I was just trying to carve out that exception to the general recommendation or advice that they contact the client and inform them of the plan for destruction. So, you know, I
understand that part of it. Like, of course, you're saying like you don't need to contact the client about destruction if you've already agreed to a agreement regarding how the file can be destroyed, as long as it complies with the lawyer's ethical duties, is what I was thinking. We could put something like that as opposed to this actual potential consequences and risks. But I do want to get feedback from others on that particular point, because I was struggling with that.
As did I, yeah.
I want to express agreement with what I take the thrust of Dina's point to be. It's very unusual, absent a fiduciary relationship and a conflict of interest kind of situation, to require informed, what is in effect informed written consent, right? So that's part of it. If we're putting something in the retention agreement, what's the ethical basis for requiring informed written consent?
Mm-hmm.
But then to me, there's another question, which is, what would be the validity of informed written consent if it allowed you to destroy something that whose loss would be prejudicial to the client? Right? Can a client make an advance waiver, even under informed written consent, of the duty of care? I think my instinct is not. Normally, you can't waive the duty of care. And while the duty not to take actions at the termination of the relationship that are involve reasonably foreseeable harm to the client isn't exactly a duty of care issue or duty of competence issue, it's very closely related. So I'm pretty concerned with the idea that the client can, so I'm sort of saying, what's the basis for informed written consent? And then the question is, would informed written consent really do anything? Wouldn't the lawyer still have the obligation, if the information is reasonably useful to the client, to contact them anyway? How could the client waive that? It's just a, now on the other hand, if it's clear that what you're agreeing to is the destruction of something that the lawyer makes a judgment is not reasonably necessary, then I don't see the need for informed written consent. I'm not sure I'm being clear enough, but that's the thrust of my concern.
I mean, my slightly confused response to what you said, Steve, sort of, I think, it reflects the difficulty in dealing with this question. I mean, and I really went back and forth in decide, trying to decide what truly is required in compliance with duty of competence and what is just merely a best practice advice. And I really couldn't come up, I couldn't, come to a clear conclusion, at least for myself, in how it should be expressed in the opinion. Because I don't want to suggest that you can not have a valid, file retention agreement, whether it's a separate agreement or, as is usually the practice, in an engagement letter. And then at the same time, examples like the ones that Ken gave is very concerning. And we want to make sure that lawyers understand that that's not something that they should do.
I guess another way to think about the question is what can the client waive upfront?
Mm-hmm.
What can be waived in a file retention agreement that what obligation that the lawyer would otherwise have can be waived?
Mm-hmm.
If we didn't have any file retention agreement, what would the lawyers? It seems to me that you could waive notice, right, with respect to things that are not your property, right? Not under the sort of property or essential document exception. You could waive notice with respect to and that are not reasonably required. The lawyer could be able to destroy documents after a certain period of time that are neither sort of essential or reasonably related to effective representation. Beyond that, I'm not sure what else the client can waive.
There's another aspect of this, and Ken mentions the 30-day or the quick file destruction. I just completed a fee arbitration, and the attorneys had waited. They had a written contract. I don't recall if it had a file destruction clause, but they'd waited till 4 years, less a day. and filed it. And then it turned out that there were some problems with the contract and some really strange rulings, but they were then put to the obligation of proving reasonable value, and they had destroyed the file. And so, you know, I'm not sure it works in the attorney's favor to have these quick clauses, but what kind of disclosures would you want to make? Okay, it's 30 days or 60 days or 3 years is up. I'm going to destroy your file unless you want it. And by the way, you might want it if you sue me for malpractice, or if we're going to have a fee dispute, or if somebody is going to claim some other right arising out of what was happened in this lawsuit. I mean, the disclosures could go on and on.
So Joel, are you saying that any kind of like disclosure of the kind of risks and consequences that are possible, like what's the point?
I mean,
Well-
sorry.
No, all I'm going to say is what I found out about over the years with regard to advance waivers of conflicts, the ones that have described the exact conflict and the risks are the only ones that are upheld. The ones that are general and don't describe the exact conflict that does come up in the future are going to be upheld. And I would imagine the same is going to be with any kind of file destruction disclosure. If you don't disclose that there may be a malpractice suit and it may be relevant what's in your file, that it's going to go against the attorney if they've destroyed the file without advising the client that maybe they wanted to hang on to it, particularly if they know of some grounds for malpractice.
I mean, maybe the way to look at it differently is to think about it in terms of like, instead of saying that's this obligation to disclose, is thinking about it in terms of like reframing it as, these are the things that the attorney should consider when determining what's the appropriate file retention policy on a particular matter, right? So it's unique to a particular matter, and that they should consider the actual and potential consequences and risks. And so in a criminal matter, those are heightened because of these reasons that we've discussed. And in a civil matter, I mean, if somebody drafted an LLC agreement for a client, that's all they did. And then after they were done with the matter, they sent them the agreement and the originals, which they usually do. Here you have everything. You know, yes, the attorney should probably keep that for their own risk management purposes. But when we're talking about duties to the client, if they've given all that to the client, you know, you could see how, what would it matter? And, you know, whether file retention policy or destruction doesn't really matter. So, I mean, each matter has presents unique issues, right? And I think we might be better off thinking about it when the lawyer's determining, you know, how to fulfill their duty of competence and how to protect the client's interest. They should consider those when they consider what is the proper file retention policy. I mean, you've already done the work. It's like, these are the things to consider.
Right.
Instead of saying that they have to disclose that to the client, because I don't even think you have that conversation with the client. You never say, well, you might want to sue me someday, so you should hold. It's just more that, you know, we've determined that there's certain time periods that seem reasonable based on our own risk management. Like, okay, 5 years is good or 4 years is good because the statute of limitations or this or that. And I'm going to then impose that in my agreements with clients, and they're going to agree to that period because of course they are, because they probably don't give much thought to it. Right. But, and when the matter's terminated, you should offer to return the file or whatever you do. But those are policies. I think that making sure that you, like Steve said, that's a really interesting point. You can't waive a lot of these things anyways from the beginning of the relationship. So it's really about thinking about, you know, the analysis, and that's the guidance that maybe we can give in that way.
I really like that idea.
I think that's really good too, because there are some situations where a 5-year period would be almost invariably, and then the question becomes, does the lawyer still is not free to destroy it even 5 years if they have reason to believe that would be prejudicial to the client, right?
Right.
But that could be a period. And you could also, I think it's also reasonable to think you could waive notice with on a 5-year provision if the lawyer reasonably believes that none of the stuff could possibly make any difference.
Mm-hmm.
But at least those are the kinds of, that might frame how you think about how you set it up.
Yeah.
A lot of lawyers, the agreements that I've seen say we're going to try to provide you notice always, even if we have a firm 5-year period. So I think it's
Mhm.
helped separate out the question of what the period should be from the question of whether you have to have notice even at the end of the period.
Well, I don't think we want to say you have to have notice at the end of the period, right? Is that what you're saying? I mean,
Could be. I mean, it could be that there are some situations where the 5 years, unless the 5 years is drafted in such a way as to provide absolute assurance, right, that, or a reasonable assurance that there's no prejudice to the client. Maybe then I think there might have to be notice.
I mean, you're saying if that lawyer independently determined that it could still prejudice the clients and then they have to turn around and give them notice of that.
Yeah, well, then they'd have to give, then they might have to get permission. I'm saying if the 5-year period squelches any concern with prejudice to the client, then I don't think you have to provide notice.
But that still require, but that would still require the lawyer to consider whether there is a reasonable basis, a reasonable need for the file going forward at the end of the agreed upon file retention period.
Unless the period is such that, given the nature of the matter, that there's a reason to think, you could have a class, it seems to me, a class of disputes or a class of representations where 5 years is, the lawyer could reasonably believe in all cases that 5 years is enough. But I think your point about the criminal case is that in a criminal case, there's probably no period which the lawyer could reasonably believe is enough. Isn't that the implication of the discussion of the criminal cases? So in criminal cases, you always have to have both a period and a notice.
A notice, right?
But I don't think that same standard applies to civil cases. I think that most attorneys in civil matters want to agree on and want to provide their clients with their document retention policy so that they don't have to go back 20 years later and go, can I destroy your file, right? I mean, that's part of the point of it. So I wouldn't think you'd have, I haven't seen the types of agreements that you've seen where it says 5 years plus I'll give you notice. I've I've seen different ones, but.
Dina, I guess my question is, if we're thinking about this, wouldn't you agree that if you're going to do that, you've got to draw that number? You got to put that number in such a way that you're confident that it doesn't pose a significant risk of prejudice.
Yeah, I mean, I agree with you that the attorney should still be independently considering after that 5-year period whether it's appropriate to destroy the file. I agree with that, and most people that I know have some type of a period and then they don't the day after the 3 years or 4 years is up, they destroy the file. They usually keep it longer than that, right? But then they have, so I do agree with that point. I guess I just don't think that the agreement, and maybe I misunderstood what you said, should say something to the effect of, this is our file retention policy is 5 years, but we'll still ask you before we destroy the file, because then it's like, what's the point in having a file retention?
Right, because most agreement would say, this is our file retention policy, and after a certain whatever time, you authorize us to destroy the files without further notice.
Another concept which comes to mind listening to all this is that whatever the disclosure is, it should be directed at why you want to take your file, Mr. and Mrs. Client, rather than why you want me to destroy it or why you want to let me to destroy it. You're going to want to keep your file in your own possession in case these following things come up, as opposed to if you leave them with me, they're going to be destroyed. But if you leave them with me, then we will destroy them after the certain period of time, despite these risks.
Does anyone else have any thoughts or feedback on this idea of like the disclosure or how we should frame that issue?
Okay. Well, Dina, so in light of our discussion, which I'm not surprised by, I don't think the opinion is going to be ready to be sent out for public comment yet. I think it needs more work. But I have a better sense now of how to make the kind of clarification that I wanted to make, but just couldn't figure out how to get to. So your suggestions have been very helpful.
Just say one thing. This is a great opinion, right? This is like a tweak.
Yeah.
In scheme of things. This is one of the best opinions that we've written. It's incredibly clear and helpful and learned. So this is a minor thing at the end of the day. I think it is an important thing though for practitioners.
Yes, because the existing opinions don't really address the whole file retention agreement issue the way that we're doing now. And as a result, I think it is important for us to address it. Okay.
Yeah, I mean, I know you've been close for a while and there's been some tweaks and we've had these conversations that have extended and but I do agree. I mean, I think that if we decide to reframe it that way in terms of what the lawyer should consider, I mean, you have all the arguments there. It's just like, it's just hopefully it's not going to take much to get it to they're good to go. Yeah.
Okay, thank you.
Thanks, Amber. Okay, why don't we take a 15-minute break, and then after the break, and so we'll come back at 3:35, and then we can discuss the Sarah's opinion on working remotely, and then we'll have give Brandon some feedback on his opinion after that. And that will round out our
Yeah, I'm
afternoon.
going to say goodbye. I've got to leave now.
Okay, thanks, Joel. Sarah, we're going to turn to the discussion of the remote, the attorney's working remotely opinion, if you want to lead that discussion.
Sure. And Mimi, if you could pull up that opinion, I can go over the edits I made from our last meeting. And first, I just added a digest in the beginning, which was missing since now the opinion is complete. One issue that I did notice as I was just looking at it quickly, again, is there's a red line in the authorities that is in there that should not be in there. It doesn't look like it's up yet, but I can fix it on my end. Just hold on a sec. It shouldn't be a red line under the authorities interpreted, but the digest is just a short summary of the opinion itself that I added. The first change made in response to the meeting is on page 2. Let me just see. Yeah, you'll stop there. And this was just to remove the language. I think this was a comment that Adam had made at our last meeting about, saying lawyers should segregate client and personal data. That was really more of a best practice and something that I think the group felt wasn't something we should include here in this opinion. So I removed that language based on Adam's comment and just added the word reasonable in the next sentence to give examples of reasonable security measures because the standard that we're talking about is the standard of reasonableness. And then if you go to, I think the next change is on page 4. The footnote 9 changes were just minor, repeating some duplicative parentheticals. So if you go to page 4, under the duty of competence, let me pull it up on my end too. Okay, so on page 4, again, I removed some of the language that kind of related to Adam's comment. That was similar to the language above and duplicative. I use the term "it is a good practice to" here, and in a couple of other instances when I was revising the ethics opinion, I thought using this instead of "should" when we're talking about something that may be along the lines of a good practice. And I saw this was something that was used in other ethics opinions and some of the ABA ethics opinions. And we don't have to include a good practice. I thought it was useful here. The next sentence was just revised slightly to deal with backup files, and a citation was added to the ABA ethics opinion that has been published since we started drafting this opinion. So I added a citation there in footnote 12. And I realized as I was looking at this, Mimi, if you could fix on your end in footnote 12, it should be a citation of 498 instead of 489. And then the other change made is on page 5 under the duty of communication. And let's see. There should be some highlighted language that I'm looking for, at least on my draft. I'm not seeing it. No, it should be further up. Let me look on my end. Draft I have up. It's highlighted language that's red. Lawyers should, let's see.
Oh, is it the footnote that you're looking for?
No, it's in the body. It's on my version. It's lines 126, 125 to 127. It says lawyers should implement reasonable measures. Sorry, I'm going back and forth. Okay, yeah, it was highlighted mine. Okay, so this was, not sure why it's reading like that. Why the client's behalf? That's not how it looks on my end.
I don't know if you're looking at my version. Like I reran the red lines to the last meeting draft, or to the last draft that was circulated.
Okay, so in any event, this section, I guess that's right. So this sentence at the end was based on Steve's comment at our last meeting. So I just deleted this sentence about lawyers should implement reasonable measures to avoid exposure to more information that's reasonably necessary. This was really dealing with avoiding conflicts, and not, as Steve pointed out, this wasn't really relating to virtual practice or remote practice. This was just a practice to avoid conflicts, and I don't think it's necessary to include here and is unrelated to the focus of our ethics opinion. So I agree with that comment and I've just decided to delete that sentence here. And the next change, these are fairly minor changes throughout page 7. Oh wait, if you could stop there, sorry, Mimi, if you could go up. So this page, this was just under the duty of supervision. These changes were really made to just shorten the opinion. I'd included a lot of discussion of the rules, but I really wanted to focus on the portions of the rules that were relevant to this opinion that I'm discussing. And so I deleted a lot of the unnecessary language, just kind of reciting what the rules state where I wasn't directly applying that portion of the rule. So this was really just more edits to shorten and streamline the opinion on the duty of supervision. And then page 7, where the other changes were, if you could now go to page 7, sorry, let's see. So here, page 7, I just added, this was also minor, but I think important issue to just, I wanted to add a reference to training, not just implementing the policies, but training is also very important. And if you scroll down, I think there's another edit on this page. Yes. Again, just changing should to it's a good practice to use on the bottom of page 7. And then I think the only other changes really made, if you scroll down to the very end, is just adding a conclusion where there wasn't a conclusion previously. And I do have one other follow-up question. In one of the footnotes citations here, I suggested adding a cite potentially to the successor planning ethics opinion, and I wasn't clear what's the status of that.
Yeah, it's still as, I mean, this might get voted out before the successor planning opinion gets voted out. So,
Okay,
yeah, we're working on another revision for the next meeting. So we'll see where that goes. But obviously you'd remove it if it's, I don't know.
yeah,
I think it's difficult, even if they were sort of on the same schedule, it's probably difficult to reference that opinion. And because unless it has already been approved, which, that process takes 9 months or so. So I doubt if there's going to be a circumstance in which
yeah.
it would be so far ahead of this opinion that you could reference it. So you
Okay.
probably shouldn't. Yeah.
Okay, and then the only other kind of general comment I have is I saw when we were discussing topics for potential new ethics opinion, there was a question raised by staff about whether this opinion discusses ethical responsibilities relating to emergency planning and emergency response. And I do briefly address that, and I don't have the page cite here, but I do briefly address that and reference the ABA Ethics Opinion 482 on that topic. So I think it is addressed to the extent it relates to remote practice. I didn't get into some of the details about, that wouldn't relate to remote practice necessarily, about advertising to victims of disasters or stuff like that. But I did otherwise address some of the issues relating to emergency planning and making sure you have access to client files. That was a key issue discussed in the ABA opinion. And the duty of communication as well, making sure you're able to communicate with your client in the event of disaster. So to the extent it relates to remote practice, that is addressed here. So I will pause now to open it up. I did email this to the subcommittee prior to our meeting, but I haven't received feedback. So I will open it up for any feedback, and I can incorporate some after this meeting too, if people want to email me still.
Sarah, I really like your changes a lot. I don't have anything more as far as I'm concerned. It feels like it's just about ready to circulate for public comment. I thought it was terrific.
Yep, same here, Sarah. I really like your digest. It's just right to the point. It gives you like the gist of what you're about to read. And I think that your instincts to cut some of the discussion of the rules as you did really helps the readability of this. And I think it's consistent with this just being a very practical read for the audience. And it seems very close to me to being ready for comments. I don't have anything else to say about it.
I agree. I think all of the edits were really good and made it succinct, and it can be really difficult to decide what to cut. And I think the things that you cut made sense. And yeah, sometimes shorter is better, and I think it reads really well.
Okay, that's good. That tends to be my style of trying to be concise. It doesn't always work, but I didn't want to be, too short. But I think it's
and it's hard when you've put in the work to like do the analysis of the rules, and then you're like, oh, I'm going to cut out all this stuff. But to decide what's the most important substance, and then leave that in there so that the reader doesn't get bogged down in quotes of rules and stuff like that I think it's really good.
I want to say, I think this is absolutely excellent. I've heard some not formal comments, but I've heard some thoughts on this where a lot of the great insights you've got here apply equally to non-remote practice, right?
Mm-hmm.
Where people are like, this isn't really just about remote practice. Maybe this should just be a broader thing. I'm not suggesting that, but I do expect we're going to get some public comment along those lines, because this is a couple steps more updated than even the prior technology opinions that are out there and stuff. And that's a real compliment. One thing I've heard, and I will say it's from some of the more defense-minded folks that I hear from, is that, for instance, when you suggest that lawyers should make sure that the smart speakers aren't listening, we've got the language in there now that it says lawyers should, and there's some people that are very concerned that we are setting people up for discipline in a way that is inappropriate. I actually think lawyers should be attentive to this all the time, and that's proper. But I wonder if we want to give any consideration to calling that a best practice versus an ethical duty to look into the smart speakers that are eavesdropping on our privileged conversations, things like that. And that's it. I think it's excellent. I think it's ready to go out for comment unless anyone wants to anticipate those comments that I've been hearing already.
I have a couple comments, Sarah. I also agree with everyone. I think it's excellent. I think it's adds a lot of value. I just have a couple on this interpreted authorities. Is that 6068? Is that like an I or an L or?
No, that's what I was saying at the beginning. I don't know how that happened. It should have just, that red line I think should be rejected. That was
Okay.
there. It should be 6068E.
Okay. And then if you want to, so going to Brandon's point, I think on line 65, I wondered if, lawyers should also disable the listening capacity, and maybe we should say lawyers should also consider disabling, or is that too, do people feel like that's too weak?
And I think for this point, I added some citations, but maybe just to the ABA. I know the ABA might address this, and I was aware previously of another, maybe I didn't cite it to here, but there's another article on this that I had in mind when I initially.
Well, that's just a thought, should consider disabling. I mean,
yeah, I see what you're saying.
I mean, I definitely think it's an area that people need to become more and more aware of. There's a lot more data and articles about, of course, how there's all these listening, anyway.
Yeah, I do like that. I mean, I think that might address some people's concern if we say should consider disabling. I'm okay with that if others are making that change.
You wanted to make that change, Mimi? Consider disabling. Line 65.
Sorry, come again?
Line 65, lawyers should also consider disabling. I mean, I know it's completely like, washing it over, but I think it at least raises the, allows people to think about this as an issue that they should be more aware of, right? I mean, but I'm okay with the other way too. On line 118, law firms should avoid unintended attorney-client relationships. And then by including these disclaimers on the website, I'm a little concerned that we're saying that we should do, like, this is like some of this stuff where we're like, it is a best practice, and you use the word should a lot, and I appreciated that you don't want to use it every time you said a good practice. And of course, I think if Andrew were here, he would remind us that we're not supposed to be writing best practice opinions, and then there's going to be that whole debate about it. But this feels like, to me, that, I mean, not all lawyers have that on their website, and I don't think that it's a problem if they don't. That's just not really smart not to do it, right? So, I mean, this is one of those areas where I don't know how others feel about that, but the idea that, like, if you don't put these disclaimers on your website that you're forming attorney-client relationships, or if you don't disclaim that you're forming attorney-client relationships, then you are. I'm a little uncomfortable with the way that reads. I mean, of course, I think most of us do it, have those disclaimers and emails and others, but I don't know. To me, it reads, as part of, it feels a little bit like, I don't read it because you're saying you're subject to discipline, but basically saying that this is, I don't know. I don't know what I am a little uncomfortable with that. So I wanted to raise that and see if anyone else felt the same with that particular point.
Dina, I actually I wanted to say that did come across to me, but I was actually confused because when I first read it, and maybe I was totally off base, but the way it read was that you would form unintended attorney-client relationships by including the disclaimer, that's what would form. I was very confused. So if we are going to keep it, I would suggest that we say law firm should put the disclaimer to avoid and not have it the other way around, because the way it's written is somewhat ambiguous. I don't think lawyers would actually be confused about that, but it took me like 3 times to read it for my brain to wrap around just the way it's phrased.
Well, so anyway, I don't know if others want to give a thought. I didn't. I just wondered if it was required to have that. I'm not saying it's bad, but you know, it's truly a best practice. It's not anything related to the duty to communicate, right? So in terms
Yeah, I understand your point, Dina. And I don't feel strongly about just removing this. I was trying to balance. It was kind of difficult as I was working on this opinion, because I know there are some things that are more along the lines like this of a best practice. But this one, I think I feel comfortable just removing it.
I mean, you could do the same type of like, they should consider whether it would be appropriate to do these things. I don't know. The advice is good advice. It's not that. And I think there's an aspect that it adds value that I'm concerned about putting it in the second sentence of a duty to communicate, suggesting that it implicates that duty to communicate, because I don't think it does under that rule, you know. So that's my comment about that. And
maybe there could be something here along in communicating with prospective clients. I don't know. I'm trying to think. Law firm should take reasonable steps to avoid forming unintended attorney-client relationships. I don't. But then I was thinking maybe we don't need to specify what those are. But
well, or you can say, because I don't know. I'm just trying to think out loud.
I kind of agree with you, Dina. I think it seems more like a best practices suggestion. It's not part of the duty.
Or you could reference the duty that we have, like the duty, because lawyers have duties to prospective clients, you know, it makes under rule 1.18, it makes sense to, I don't know. I'm just trying to think of, because sometimes you don't even want the person to be a prospective client, right? I mean, it's like, you know, anyway. Yeah.
Well, I mean, if people feel that this is too much of just the best practice, maybe we should just remove it.
Well, I think we should consider that. I mean, I don't think we should consider removing it. I think we should, unless we think we're going to be voting this out today, which I would hesitate to do that because Andrew's not here. And so even if, I mean, this is, I think we all would probably agree is very, very close, if not probably. I would still think that maybe we want to think a little bit more about that best practice piece part of it.
Sure.
And I would like to get, you know, his feedback on it. I mean, I definitely think that's going to be the feedback we get from a lot of the bar associations. And I'm not saying, but I also think it's very valuable, and it provides a lot of value. So I don't want to take it. I don't want to make the decision right now to take it out. I just think that maybe we discuss it again next week. So
I can try to work on this highlighted part that Mimi just highlighted. So I'll see if I can come up with some better language to address your concerns.
Okay. And then the other comment I had was on line 219, which is near the end of the opinion on unauthorized practice of law, that section. And I wondered if that second sentence of the first paragraph, I was thinking the committee is not authorized by the state bar to opine on whether this may constitute the unauthorized practice of law under certain circumstances. Because it's not really issue an opinion, or it's really, we're opining on whether it constitutes the unauthorized practice of law. I thought maybe that'd be a better wording of that, under certain circumstances, right? So whether any particular circumstances.
Yeah.
You know,
I understand. I think we should make that edit. That's clear, and it's not just these. It's at really any sort. We can't opine. Period.
Do you want me to type that?
That would be great.
So
Yes.
put it, by the state bar to, instead of to issue, Mimi, say to opine on whether this may constitute and then you can keep the rest of it, and then I'll make one more change. Under certain circumstances, because it's not just, or under any circumstances, I don't know what we would say.
Do we even need under certain, maybe we can just delete under certain circumstances that's ended after unauthorized practice of law. Well,
Yeah, okay. I mean, then would we say, however, the committee is not authorized? I know we don't like extra howevers, but I just wonder if we want to tie those sentences together more. I don't know.
I'm okay with adding however there, if that makes sense.
I think the however fits there.
Despite the old school convention that you should never start a sentence with a however, but anyway.
I know, yeah, that's true. We just did a committee, however.
Yeah. Okay, those are just the comments that they're small. I just think you've done a great job with this, Sarah. I hope others might have comments too, but even, we can hear those comments. Anyone else have any comments?
Okay.
Okay, well, my preference would be that we just hold this till the next meeting, and it looks like it's really close, and we'd probably be in a position to vote it out. We can give a little more thought to that sort of best practices language, or however you want to look at that, and your subcommittee can think about it too. But it's really great.
Yeah, I was having a hard time. I feel that if you don't get into them to some extent, the opinion really isn't adding much value. And when I looked at some other opinions on this topic as well, it seems like a lot of bar associations do provide some guidance, and I think some guidance is appropriate. And they frame it as a should as opposed to a must, or the ABA in other opinions has used it's a good practice. And so I think we should avoid doing it too much, but I think some is.
I mean, I think the way we've gotten around it in terms of the rules is just with the 5.1 stuff, right? Where we basically say, like, you have these duties to have policies and procedures to make sure that we follow the ethics rules. And so these are policies and procedures that you would implement that would help you to have, that would comply with 5.1. And that's how we've kind of gotten around is this a best practice thing, which is just to say it's all part of like what should be reasonable policies and procedures to effectuate and,
Yeah, that makes sense. And that was what
I don't know if it would work in this structure.
It worked at one point in the opinion. In the beginning, the first edit I made was saying other reasonable security practices include. Yeah. So maybe I can try. It might work in others too. I'll consider that.
Yeah, and I don't know how wedded to that, idea people are. I mean, it could be that you bring that discussion, first, the duties for, I don't want to rewrite the opinion because it's in good shape, but just the discussing 5.1 and then how it implicates all these other things. But, I think it's very readable. It is very compelling. I think it adds a lot of value. So I done a good job. Okay, thanks, Sarah. Any other comments? All right, Brandon, take it away.
Well, I can make it quick. There's so the changes I made to the opinion are really in two areas. The one is that I changed hypothetical number 3 of the 5 hypotheticals, and I'm just sort of flailing. I'm looking for a hypothetical that everyone seems okay with the other 4, and I'm trying to come up with a hypothetical that grabs people's imagination, illustrates a point that we think is important, and comes to a result that we're all comfortable with. So this new hypothetical is completely fresh, and I'm not sure if everyone's going to like the result I came up with, or how they feel about it. And maybe we could stop there, Mimi. The area that I'm struggling with even more is in the red line. It's the paragraph starting at number 152. And I had a concept in the earlier drafts that we all seem okay with, which I'm trying to root to some authority or specificity, and I'm having a very hard time with it. It's the concept that a conversion clause is potentially permitted if, when terminated by the lawyer, it's only terminated by the lawyer for cause as defined in Rule 1.16a, mandatory withdrawal. Or maybe I have that backwards. And then for the client, you're only going to trigger a conversion clause if the client terminates the attorney without cause or without a good reason. And then it may be permissible. And I'm having a really hard time. I mean, that's an easy sentence that doesn't seem objectionable, but I'm having a hard time figuring out what it is for a client to have cause to terminate an attorney, because it seems like it could be a million scenarios that would have to each be independently evaluated as to when we think a client's termination of his or her attorney is justifiable or has cause, as opposed to a whim. Because a client is always entitled to terminate his or her counsel for any or no reason. And that's really where I'm struggling, and I don't want to just say something as simplistic or reductive as, where the client terminates the attorney without a good reason or without some sort of failure or misconduct by the attorney or something like that. I was trying for this great symmetry, right? And I've seen other ethics opinions of other states or other bars that have said just the simplistic version that we started with, that don't put any more authority or nuance on it. But I'm anticipating that if we're ever to go out for public comment that way, people would say, what do you mean? What are you talking about? And I'm not giving them much clarity. And I'm not expecting everyone to solve this at 4 o'clock on this, at this meeting. But I just want to bring, this is the main thing I'm struggling with right now, is this paragraph and where to look for guidance or how to restructure the concept if we think we have to change it. And it's something everyone can just ruminate on for the next meeting. And I'll freely admit I have not made proper use of my drafting committee too. So I want to dig in with the other folks on the drafting committee and see what we can figure out here too. But to me, that's the biggest challenge that I'm seeing in front of me right now. If anyone has any genius ideas, I'm all ears, but I don't expect anyone to just come out of the blue with a great idea. If it occurs to you, I'd love to hear from you.
Well, I don't have any genius ideas, but I have some thoughts.
Yeah, I guess I'm really putting too much pressure on anyone to speak that way.
So yeah, Brendan, I kind of also was drawn to the discussion of 116 starting at line 152, and I'm having the same struggles as you. Just as a minor typographical note for Mimi, I think we need to say at 162 that permissive withdrawal is part B, and then 165 mandatory withdrawal is part A.
Yeah, I flipped them. I'm sorry about that.
Yeah, no worries. But then I was thinking about, well, does this dichotomy that we're drawing really work when you look at the bases for mandatory and permissive withdrawal? And right now, where I am in my own mind is no, the dichotomy, it can't be drawn so simply, because, I mean, take for instance, 116A1, right? So mandatory withdrawal if the lawyer knows that the client is, bringing a claim to be harassing and has no probable cause. Well, B1 for permissive withdrawal isn't all that different. You know, if the client insists on presenting basically a frivolous claim, which you know is very similar to the mandatory withdrawal basis in A1. So if a lawyer isn't comfortable with a client's insistence of pursuing a frivolous claim and has the may withdraw under those circumstances, to me, you know, this idea of with cause doesn't really play very well, because it, you know, just my gut is it doesn't seem like a fair distinction to draw that, you know, the alternative fee would be okay under A1, but not under B1, given
You're
how
absolutely right.
similar they are. And maybe I'm, you know, so that's where I'm struggling with the dichotomy is that I
We
don't
also
see.
have this, like, there's the interaction of this Russ Miliband case, which is basically where the attorney, the contingent fee attorney, loses confidence in the matter and bails. That attorney is not even entitled to seek quantum merit fee, right? If they have walked away from the case because they just don't believe it's going to recover or has merit or whatever it is, you forfeit even your quantum merit right. So I think I'm coming around to the idea that 1.16 should not really be part of this discussion. It's not going to be a useful test. And then the next step for me to figure out is whether the concept of with cause or without cause can be workable, and whether there is a good test or a good conceptual peg we can sort of hang our hats on, or how to deal with it. And because the more I look at 1.16, it's not going to work. I mean, the ambiguities you're talking about are just too great. So I think I need a new approach, and I'm just not sure yet what it will be.
You mentioned that there were some other maybe out-of-state opinions that have touched on these types of issues.
Yeah.
Is there anything to mine there that might be helpful in kind of reformulating this?
I'm going to look further than what I had already found, because if you look at my concluding sentence there that starts on 167, where I just sort of conclusorily say when it might be permissible or prohibited, a lot of these other opinions that I looked at reach the same conclusion, but don't dig in. They've just ignored the analysis that I was trying to come up with here. But I'm going to I think I just need to research again and see if anyone's touched on a useful tool for this analysis, because I haven't seen it yet.
And in the Miliband case, I mean, how do you may not know offhand, but how far does that case go, and has it been picked up for any of these? Sorry, sorry if you can hear my kids. Has it been picked up for any of these fee-related issues in subsequent cases? Is there anything to mine there, or have you kind of fully exhausted as far as that one goes?
Let me chase it further and see. Yeah, because the case itself, I don't think gives us too much to work with, but I'll see where it's, because it is the leading case still on that concept, I believe. So I'll see where it's been applied and analyzed in other cases. That's a great suggestion.
Yeah, I'm with you. I'm not sure that 1.16 is going to be our touchstone here for a framework.
I mean, I think either way, it's like I mean, this doesn't really go to the crux of your opinion, Brandon, but like you're basically like creating a situation, the attorney is, where they're going to be litigating like what's good cause. I mean, no matter what sort of paradigm you set up, it's going to be related to the termination of the attorney-client relationship. It's not usually going to be a situation where both people think this is great, we're terminating our relationship. I mean, even if the client does it, the client could be like, hey, I had to because they never contacted me or they failed to communicate or whatever the reasons. There could be sort of good cause for that termination. And you're going to always be sort of litigating, or it's going to be a separate issue if you have those standards as to like, was that something that was, whose fault was it? And should this trigger happen? you know, what is good cause if you have good cause, or is this really it's one, you know, 16A1 or AB, you know, B1, or, you know, it seems like, I mean, that's just sort of a note, not necessarily related to how you formulate this, but I mean, the problem with this from the attorney perspective is you're just creating another thing that you're going to have to litigate down the road, right? Like,
Right.
to determine fees.
Well, and that's one of the interesting things is that depending on the way that the attorney-client relationship is severed, the Ross Miliband case, you know, is already going to be a point of contention, right? You're going to have to, an attorney will have to show that they were justified in their withdrawal, and that's the sort of a concept from the Ross Miliband case, and that firm in that case failed to show that they had just lost confidence, and therefore you walked away not expecting a fee. You don't get a piece of what the next attorney, the rabbit they pulled out of the hat or whatever. And so maybe I just need to zoom out, because the crux of this was I didn't want, and I thought it was the sense when we talked about it of the committee, our sense that conversion clauses that are subject to manipulation by the lawyer are improper. You know, where a lawyer could always just be looking at the case and say, well, at this point, I now think the recovery on the case, my fee against that recovery will be smaller than my hourly fees would be. So I'm just going to abandon this case, trigger this clause, and come out ahead and, you know, wreak a terrible result that we all want to avoid. And I think we all agree that a clause that would incentivize or permit that sort of manipulation by the attorney is improper and impermissible. So maybe I don't need to go much further than that. Maybe I should think about simplifying this. I was trying to get this like 4 category symmetry between when an attorney does this with or without cause and when a client terminates with or without cause. And I think it might be too cute and it's not going to work. So, because you raise a great point. They're going to
Yeah,
be
I mean, I think the attorney needs to consider, and maybe this is in here, but just if they're going to consider using a conversion clause, that, you know, that the potential consequences of the conversion clause could never be like the unconscionable or illegal fee, right? So they have to, there's got to be a cap on that quote unquote conversion, or there's got to be some, or it's an improper clause, right? So if there's some result under which they terminate, if it's based on termination and that's when it converts, or whatever the circumstances under which it converts, if they are unjustly enriched by that particular scenario, then that's improper, or they need to, then that's a clause that shouldn't be in there, right? There needs to be sort of a cap or a hatch or something on it. So yeah, I mean, I think it's worth noting in here that of course, if they do terminate, it always has to be under Rule 116, right? I mean, I think we note that. That's important, I think, to reference the rule in general for that reason. That you can't, like the case says, you can't just terminate for other reasons. You has to be one of the, I think we agreed on that it has to be based on that rule. Of course, there's a lot of wiggle room in the rule to have a reason to terminate. But we usually document those reasons under the rule, right? So
So there's, I mean, and I know we're at the end of the day, but something occurred to me in our earlier discussion of the improper contract provisions is whether we want to consider an additional analysis in this or topic in this opinion that talks about where, because this is basically about whether laws is ethically permissible or not, but it's not express about whether it subjects the attorney. So let's say you put a conversion clause in that is completely improper, but the client never, the relationship is never terminated, and everything goes to fruition. Is it improper and subjecting the attorney to discipline just even to put this in the fee agreement for the same reason we're talking about, the chilling effect? Like maybe that relationship, maybe that client would have wanted to terminate that attorney, but was afraid of this punitive clause, didn't do so. And it's an improper, unenforced clause. And the only reason that it wasn't triggered was because of the in terrorem effect. Do we want to touch on any of that in this opinion? I don't want to complex, but I wonder if we need to say something about that. Like, do we think an attorney should be subject to discipline for putting these overreaching clauses in the fee agreement, regardless of how things play out?
I mean, it might be worth mentioning in a footnote or something. I mean, I don't know that there has to be a lot on it, but I do think it's an interesting point that like you don't want to say, you know, I mean, it's the same rationale. You shouldn't be putting, you know, provisions in your fee agreement with your clients that you know are completely improper, whatever. I mean, again, it's one thing to say, I don't think an arbitrator would uphold this. It's another thing to know that it's, you know, unconscionable. I mean, I think it would be hard. Maybe it wouldn't be hard to identify a particular clause. Like, yeah, I get 100% of the recovery if this happens.
Right.
It's okay. Well, that would be very obvious, right? So,
Right.
yeah.
Well, they come along every once in a while. Yeah, maybe I'll see what I can come up with, and I'll work with my drafting team. I mean, it's a great resource that I have been too late each time to really take advantage of. So for the next meeting, I'll have to have that fleshed out a little better.
That sounds great. Any
Okay.
other questions you have or you want people to think about or comments?
No, really, I mean, just see if third hypothetical is appealing, and we don't need 5 hypotheticals, and if we're somehow struggling to come up with number 5, you know, so, but that's all I'd like to talk about at the next meeting.
Okay,
All right.
that sounds good. All right. Thank you so much, Brandon. Sorry, Ken, we didn't get a chance for yours, and we'll hopefully prioritize those for the next meeting. And everyone have a great Friday, and yeah, see you later.
Thanks.
Thank you very much.
Thank you, everyone.
Thank you.